Greetings, Maryland Realtors members. My name is James Beslety, and I'm a staff attorney here in our Legal Affairs Department. And I'm here today with Kathleen D'Artez, my supervisor, our Director of Legal Affairs. And we're pleased to offer you this recorded webinar discussing 2022 updates to our statewide forms library. And Kathleen, we have been traveling across the state, both virtually and in person, talking about these exciting and substantive changes to our forms library. And I think we thought it would be good to get a comprehensive video in addition to the other resources that we have available to our members to discuss these changes so that folks can take a look at them on their own time and really do a deep dive into this year's changes.
Right. Thank you, James. Yes, exactly. And thank you everyone for watching. As James had just said, we wanted to record this so it would be available to all of you as a resource. Maybe if you're a sales manager, if you want to show it during a sales meeting or show segments of it during a sales meeting to help train your people, we just wanted to have that available for you as needed when needed.
Exactly. So this will be up on our website. And I think we're going to start off, we're just going to go right into it with our documents and forms. And we do want to start off with our manual of changes and practice tips. Just bring that to everyone's attention. The main resource I'd say that is available on our website at mdrealtor.org. And I have that up here for you. The very first page, you'll see its title, 2022 Statewide Forms Manual of Changes and Practice Tips. And Kathleen, in previous years, when we do have changes, and we typically have changes every year to some extent, we've titled it a summary of changes and practice tips. But I think this year we wanted something a little bit beefier, if you will.
I hope that's not intimidating for our members, but it's a little bit more, it is beefier is probably the right word. It's a little more thorough, and the changes are a little bit more comprehensive this year. Some of them are just matters of style, and things that you're used to seeing in certain places will have been moved around in the contract. So we just wanted to go through and explain how the process worked a little bit, how these changes were made, kind of an overview, and then a little bit more of a detail on some of the specific changes. And again, of course, as we always do, some suggested practice tips or best practices.
Absolutely. And I'm just scrolling through this document very slowly. As I mentioned earlier, it is available on our website. And in particular for the contract of sale, I did want to go section by section to highlight the changes and incorporate those practice tips. When it comes to the other documents, we discuss each of those documents that are either new or updated for 2022 one at a time. And you'll see heading, for example, for the property inspections addendum. One other thing that I'll point out at the very end of the document, it does indicate forms that are retired for 2022, and that would include the disclosure of leased items addendum to the contract of sale, the inclusions, exclusions, and utilities addendum to the exclusive right to sell residential brokerage agreement, the as-is addendum, and the first-time Maryland homebuyer transfer and recordation tax addendum. So as of October 1, those forms will no longer be made available by Maryland Realtors, and we'll be making reference to those forms as we go through the rest of the changes, primarily to the contract of sale later on in the webinar. The other educational document we wanted to bring to your attention is this Condominium and Homeowners Association Forms Practice Guide. Now, this was something that our statewide forms committee at Maryland Realtors approved. And I mean, Kathleen, you can certainly speak very well to this, given how long have you been with the association now? 8 years?
2015.
2015.
Yeah.
So I would say it's probably fair to say that condo and HOA questions are very common amongst our members.
Yeah, we get on the legal hotline, we have a lot of questions about which forms to use, and sometimes the titles aren't always clear, and that's a pretty recurring question. It's a perennial, right? It comes up every year. We always have questions on condo and HOA forms and how they're to be used. What if the documents are not received? When should this be signed? When should it not be signed? It's sort of a continuing thing. So James, to his credit, took on the task of sitting down and typing out a guide to help everyone determine which forms should be used, and basically how the process is supposed to work, what's supposed to happen.
Right. And what we hope to accomplish with this guide, and it is just that, it is a guide. If you need more substantive information, advice, we strongly encourage you to contact your broker, office manager, or team leader. The legal hotline at Maryland Realtors is also available to you as a resource if you need more information. But this is really just meant to provide some guidance regarding the condominium and homeowners association forms that we do offer in our statewide forms library. And as Kathleen said, just kind of flesh out a little bit more of a timeline of what needs to happen when, to an extent when it comes to condominium and homeowners association transactions. And as you can see, I'm just kind of scrolling through. This form's a few pages long. So for those of you who are looking for a refresher, maybe you haven't had a condo or HOA transaction in a while, or for those of you who are brand new to those types of transactions, I know certainly in some parts of the state, they're much more common than others. I think I read somewhere that 1 million homeowners in Maryland are subject to have a property that's subject to a homeowners association. So
Oh,
that's a lot of folks.
it
Uh,
is.
and certainly, as you'll see in this document, there are certain requirements for providing documents and information to purchasers, as is stated in the Homeowners Association Act, i.e. buyers. Vendors, i.e. sellers, have those obligations. And their agents typically assist with that process. So I think this is a great resource now to have available. Again, it's on our website to our members who are engaging in those sorts of transactions.
Right.
So we wanted to start off with those two educational documents, but now I think it's time to dive into the contract of sale.
Yes.
Kathleen, did you want to maybe briefly talk about the contracts review task force that was assembled by our association's president, Craig Wolf, and
Yes.
how that played into the process here?
Yeah, thank you, James. I'm not sure how familiar everyone is with the process. This year we had a special process. The 2022 Maryland Realtors president, Craig Wolf, he had talked to a lot of people and had heard comments and suggestions. And there were some suggestions made that maybe, it might be a good idea to take a good look at the contract and see if the contract could be streamlined or reorganized or just improved to make it more user friendly, both for our members. And of course, ideally, we're explaining it to our clients and customers. So sort of a two-pronged goal there. And Craig took that to heart, and that was one of his initiatives in his year as president. And he appointed a task force to do just that, to look at the contract and see if it could be improved, streamlined, reorganized. And the task force met many times, many times. The task force was led by Tom Drexler with Sage Title, and there were 9 members of our association who served on that, served very, very capably and gave generously of their time and talent to work through these issues. And they made some recommendations. And how it works, the task force recommendations, all changes to the contracts and to our forms flow through the statewide forms committee. So the task force spent their time working on this, made some recommendations to the statewide forms committee. The statewide forms committee discussed some of them. They reviewed everything. They approved the changes. And then it has to also go up the chain and be approved by our executive committee. So everything that we're going to discuss from this point forward was recommended by the task force. And then in addition, there were other changes that were recommended by the statewide forms committee and approved by our executive committee. James and I did not just sit around deciding we're gonna pull some forms and delete them. It was really done by committee and through a bit of a process, to be honest.
Absolutely. This was a very, very member-driven process. Of course, we as in-house counsel at Maryland Realtors were there to provide our guidance and support, but these were changes that were driven by members and in particular their knowledge and expertise in our industry, informed by that knowledge and expertise. So wanted to set that forth for everyone so that our members understand where this is coming from. I think that's really important as part of looking at the forms today. So I'll go ahead and share the screen again.
Right.
So we have our contract of sale up here. Our most commonly used document. I'm sure everyone's using this to transact their residential business here in Maryland. So I think the first thing that I typically talk about when I do these sorts of sessions, these presentations across the state, is the fact that a lot of the content that you are all familiar with in the residential contract of sale has stayed the same. Really important to emphasize that. What has been invested in this form, its time, its talent, its financial resources, And I think the task force, as well as us and our guidance and support of this process, what we were very deliberate about was not reinventing the wheel where it didn't need tweaking. So when you see things that, particularly in this form, that have not highlighted things that are not highlighted, things that we don't say have changed, it's because they haven't changed. We kept the best of what has worked for years, and have made adjustments and updates to things that we hope will work better in the future. And one of the ways that we maintained the best of what's worked is reorganizing that content into sections. So we now have 7 sections in our contract of sale, and we'll go through this document and you'll see each of those sections one after the other. But section 1, I think, is where a lot of the material terms to a contract of sale for a piece of real property are going to be found. So here in section 1, general contract provisions, you'll see date of offer. You'll also see our time is of the essence provision. Now, this language has pretty much stayed the same, but before, Kathleen, right, it was in a box.
Yeah.
We had
Yes.
the box.
It was in a box above the title and no one read it.
Right. So, and I think we're trying to get away from boxes.
Oh, I don't know if that's a big policy decision we've made, but just coincidentally, yes, we have eliminated quite a few boxes.
Some boxes. So now it's simply paragraph 2 in the contract of sale. It's always been a part of the contract, and we wanted to really emphasize that it is by giving it its own paragraph number. But otherwise, you're going to see a lot of familiar
What I
provisions.
was going to say,
Oh,
thanks
sure.
for your pause for one thing I always want to mention on this, just time is of the essence. It does say if something's supposed to happen within a prescribed time period, it shall be a default. The non-defaulting party, upon written notice to the defaulting party, may declare this contract null and void and of no further legal force and effect. I always mention that because if a very easy example, let's say the buyer doesn't show up for settlement. The settlement is supposed to take place today. The buyer does not show up. The buyer is in breach. The contract doesn't just automatically die tomorrow. It doesn't terminate on its own, right? The non-defaulting party, in the example I just gave, that would be the seller. The seller has to send written notice to the defaulting party, which is going to be the buyer, send written notice to the buyer that the seller is terminating the contract. We have a unilateral notice. That's a very easy example of when it's appropriate to use that form. And I would strongly encourage you to use that form, because I always think of, there was one case where a licensee was disciplined by the real estate commission because they did not terminate the original contract, encourage the sellers to sign a second contract, and then the sellers ended up in a big lawsuit, having contractually obligated themselves to sell their property to 2 different people. So I do like to just emphasize that, and just remember that if you don't remember the whole thing I just said, the contract doesn't die automatically after the settlement date or after something does not happen. Basically, you have to kill it. It doesn't die on its own. So send that unilateral termination if it's appropriate. Like I said, the easiest example to think of is if the buyer does not show up for settlement. That's a very easy example to remember.
Absolutely. Those are excellent points, and really informed by the sorts of questions we get on the hotline. And indeed, we get a lot of questions about contract termination in general. Certainly, there are instances, for example, when you have a breach or when someone is exercising a contractual right that they have to terminate the contract, when the unilateral notice of termination under contract of sale is the appropriate form to use, and it should be used.
Right.
Of course, there are other instances where the parties may come together and say, you know what, the universe does not mean for this home sale transaction to occur. And in such an instance, you would use the mutual release of obligation under contract of sale in order to terminate the contract. And in all those instances, if an earnest money deposit is at play, Maryland law requires that the parties agree to the release of those funds by way of a release of deposit agreement. So you're usually going to need both forms. Of course, a dispute over an earnest money deposit can survive the termination of a contract of sale, something to be mindful of, but a great opportunity to talk about that a little bit. I appreciate in general just all of the renewed interest in education that we've seen from these forms updates.
Definitely.
But so moving on from paragraph 2, space to indicate who the seller is, who the buyer is, identifying the property, the way the property is being conveyed and what estate rather, or so in fee simple, perhaps subject to a ground rent, the purchase price, I spend quite a bit of time talking about paragraph 8, payment terms, not necessarily because the content has changed, but because I've seen a massive uptick in calls related to earnest money deposits that are not being held by a Maryland licensed real estate broker. So we do have a sort of a bold notice here in the contract. If deposit will not be held by a Maryland licensed real estate broker, the parties shall execute a separate written escrow agreement that complies with Section 10802 of the Real Property Article Annotated Code of Maryland. So why is that there? That is there because if an escrow agent, i.e. a title company, is going to be holding the buyer's earnest money deposit, the provisions that govern how that earnest money deposit is to be maintained and perhaps how disputes are to be handled, they're all contained in an escrow agreement. And in fact, we offer an escrow agreement that was developed in concert with the Maryland Land Title Association in our statewide forms library. Why do you not need an escrow agreement when a broker's holding the earnest money deposit? Well, the Maryland Real Estate Brokers Act has provisions that govern how brokers are to maintain earnest money deposit funds as well as handle disputes. And in fact, our escrow agreement mirrors those provisions. They're very similar to what's contained in the Brokers Act, but there is no statute that holds a title company's feet to the fire, so to speak, in terms of how they are to maintain those funds and how they are authorized to disperse them, for example, if there is a dispute or the contract is terminated. That's all set forth in the escrow agreement. And many questions I get, Kathleen, and I'm sure you could speak to this as well. Well, the parties didn't enter into an escrow agreement and now we have a dispute. What happens? Well, that's not my favorite question to have to answer.
Right. Maryland law requires that there be a written escrow agreement, period. That's the answer. So that's not the answer, but that is a requirement of Maryland law. If someone other than the broker is holding the earnest money deposit, there has to be a written escrow agreement, period. I know that, for whatever reason, maybe it's difficult getting a copy of it back. There's a challenge, but basically the bottom line is absent that agreement, there's no legal provision that specifies what's going to happen. And that actually is one of the reasons why we worked with the Maryland Land Title Association to develop the form. I think, from the seller's perspective, there were some concerns without a written agreement. Title companies generally get their business from buyer's agents. If there's a dispute, is the title company just automatically going to send the money back to the buyer? And then even for protection for the seller, how do I know that the title company has received the EMD? How do I know that the check cleared? All those sorts of things. So there really are, the seller is well protected or better protected. The buyer is actually better protected as well by the agents making sure that there is a written escrow agreement, that you have it back, you get it back from the title company, it's signed, and the parties understand what's going to happen in the event that there's a dispute.
Absolutely. And another point that you raised there, always follow up, whether it's with a title company or a brokerage is holding the earnest money deposit. Follow up to ensure that the buyer has timely made that earnest money deposit. I get a lot of calls. It's been 3 weeks since we went under contract, and the buyer is attempting to terminate the contract or walk away, and I just realized that they never made the earnest money deposit. Well, another tough question to have to answer, because you really do want to be following up with either, again, the escrow agent holding the earnest money deposit, or if it's a broker, the brokerage, to ensure that it's been timely deposited. But something that I do take a little bit of time to talk about, because that has been a legal hot topic, if you will, over the last several months.
And I always just think you do not want to be a listing agent and have to tell your seller, the transaction falls apart 3 weeks into it. That is not when the seller wants to find out that the EMD was never collected.
Absolutely. Great point. So rounding out page 1 of 11, the deposit paragraph has remained the same. Of course, any disputes the deposit is to be dispersed in accordance with the terms of this paragraph, and really what we're talking about. If the transaction is terminated or settlement does not occur, a release of deposit agreement is required between the buyer and the seller. Unless they cannot agree, then we're talking mediation. Certainly the entity or individual holding the earnest money deposit is going to have some other avenues of resolution available to them. One thing I'll note about interpleaders, I'll talk about very briefly. So if, and this is an option that's available to brokers as well as pursuant to the terms of our escrow agreement, escrow agents, they may take the disputed funds and to make a long story short, deposit them with the court, with the instruction to the court that these two parties are disputing these funds. I need to wash my hands of this dispute. Court, you go ahead and handle it. Note that escrow agents are able to, and I believe real estate brokers, they are able to deduct any costs or fees associated with filing that action for interpleader from the amount of the deposit. So it really is to the benefit of parties to a contract to come to an agreement about how that money is to be dispersed before it gets to that point, because once you start making deductions off of amounts of deposits that may be lower, you are then wiping away the amount of disputed money anyway.
Right.
So I think something worth mentioning.
Very good.
Of course, the settlement date here is at the bottom of page 1, and I suppose we might as well, since we're at the bottom of the page, talk about initial lines. There are no initial.
Wait, I don't see them. Where are they, James?
They're gone. And I've actually gotten a fair amount of positive feedback on this, because our members consider this to be a compliance issue. Certainly, if there are some pages that are initialed and other pages are not, that does not bode well necessarily. But what I really just want to hit home about initial lines at the bottom of pages, at the bottom of every page, there's really no legal significance to them. What's really legally significant and controlling are the signatures at the end of this multi-page document, which is construed together, is taken together as one document, page by page, not only by the expression of the page numbers here, but by the fact that you have paragraph 10. Oh, and on the next page, paragraph 11. It logically flows all together, legally flows all together as one document, such that you don't need those initial lines. Really, the only places that we like to have initial lines in our forms are places where the parties need to signify, memorialize rather, an agreement within an agreement within the form that constitutes a larger agreement. So something that I wanted to mention as well.
Right. I would just add one thing to that. It's consistent with what you had just said, that the initials generally did not have any legal significance anyway. Certainly the initials at the bottom of the page. I know we would have a question on the legal hotline periodically where someone was trying to get out of the contract and perhaps say that it was not valid. Somebody, oh, the seller forgot to initial page 3. Does that means we don't have a binding contract? And that was never true. So the loss of the initials may not be as significant as you think. And I think, as James had said, the feedback that I have received has also been fairly positive about getting rid of those initials on the bottom.
Excellent addition there. So now paragraph 11, addendum disclosures. And remember, we're still in section 1 of the contract. Some additions here. In particular, I think we can start off with the tenant occupied addendum. That was a form that we've had for some time, that's my understanding. But for whatever reason, we didn't have a checkbox here in our addenda disclosures paragraph. And I think this is an important form to use, and I'll bring it up briefly. The form itself has not changed, but we just wanted to reference it in the addenda and disclosures paragraph of the contract. Certainly, if there is an existing lease in place in a property that's being listed, this form should be used to bring buyers on notice of the fact that the property is tenant occupied. Oh, and by the way, here is a copy of the lease agreement containing the terms of the tenancy, and perhaps if there are any issues at present with regard to the tenancy, that can be disclosed in paragraph 6. This is a one-pager. It's not a extremely complicated form, but again, I think something that was worth referencing in our addenda disclosures paragraph, because it is part of our statewide forms library, and something that should be used again in the event you're listing a property that is tenant occupied, and in particular if it will remain tenant occupied beyond the settlement date.
Yeah, I think it's helpful in in a practical sense. For example, even just something as simple as the security deposit. If you're utilizing this form, it'll walk through the paragraphs and you'll say, oh, yes, the security deposit. That's right. The landlord's going to have to transfer the security deposit. Excuse me, the seller's going to have to transfer the security deposit to the new owner, who will then become the landlord. That's going to be shown on the settlement statement. Rent, if the tenant has prepaid the rent, and settlement's on the 15th, the rent's going to be prorated. That's going to be shown on the settlement statement. The first half of the month is going to remain on the seller side. The second half of the month is going to be paid to the buyer. So it kind of walks you through most of the issues that you should be discussing. So it's a great form.
Absolutely, absolutely. So besides the tenant occupied addendum, we have 3 additions. We have checkboxes for the additional as-is provisions addendum, the disclosure of ATU, BAT on-site sewage disposal systems, and the disclosure of inclusions, exclusions, leased items, and utilities addendum. We'll talk about those first 2 a little bit later on in the session, but now is a good time to shift gears to the briefly to the disclosure of inclusions, exclusions, leased items, and utilities addendum. Now, previously, those of you who have worked with our outgoing contract of sale, inclusions and exclusions were reflected in paragraph 13 of the contract of sale. There was a separate form for disclosure of leased items. When you were listing property, we had an addendum whereby the seller could indicate what they plan to include or exclude in the sale and what utility service the property. Many different places for this information to be expressed, not to mention in the multiple listing service. And whatever information a buyer's agent had regarding those items would generally come from the MLS and go into the offer made on our residential contract of sale. And I think the general feedback, this was a form that was developed by our statewide forms committee solely, and the feedback they considered was there were too many, sort of like a game of telephone. I've been referring to it as, too many breaks in that chain where a misstatement, an error, a data entry error could be made. For example, a seller doesn't intend or wish and has represented to their listing agent that the fridge in the kitchen is not being conveyed, that Sub-Zero is coming with me. And in fact, for whatever reason, perhaps by accident, it's indicated in the MLS that, oh, the fridge is included. And so the buyer's agent puts that in the contract. Perhaps someone does not review the contract carefully, and suddenly, based on the terms of the contract, that Sub-Zero is staying with the property.
Right. The agent's buying a fridge.
Right. So this form is really designed to compress all of those potential links in that chain, if you will, giving the seller the opportunity to directly indicate on this form. And you'll see we pulled the language that worked in paragraph 13 directly from paragraph 13 and put it right here into this disclosure addendum. All of the possible items that could be included or potentially excluded, leased items that may be included with the property, as well as utilities that service the property. This document, unlike the addendum that we used to have to the exclusive right to sell residential brokerage agreement, may become an addendum to the contract of sale once executed by all parties. So it starts out its life as a disclosure by the seller. The intent, the idea is that you upload it to Bright, so the buyer's agents can pull it right down. You don't have to take any information from here and input it into the contract of sale. It just becomes part of the contract once everyone has signed. So I'm really excited about this change to the forms library.
I think all the feedback that I've received on this form is the same, James, very favorable. And again, I think it's going to help consumers and your clients, obviously, ultimately, as well, as James had said, just reducing those opportunities where a typo could be made or a mistake could be made, something could accidentally be, omitted or accidentally included. So yeah, that would be posted on Bright MLS. The buyer's agent would pull it, have the buyer sign it and submit it as part of the offer. Seller signs that everything is consistent with what the seller initially wrote. The only one thing I would caution now, as the new forms are becoming effective, I would just caution everybody to be aware of that. The new contract does not have inclusions and exclusions in it, as James had just said. So it is critical to make sure that you are using this addendum so there is an agreement as to what's being included or excluded. If you do not use this addendum, there's nothing in the contract to specify what is going to happen, what is going to be included, what is going to be excluded. So I would really focus on that. All of you who review contracts, at least for the interim, pay particular attention to that to make sure it's included as part of the offer and as the contract.
Absolutely. And as we'll see later on, as we roll through this form when it comes to property condition and noting inclusions and exclusions, there is a statement in the contract that makes direct reference to that disclosure. So we do hope that everyone is reading carefully the forms as they're using them. Really important.
Of course,
Of
James.
course, yes, always. So this paragraph 12, really just briefly, we used to have separate paragraphs that related to the parties agreeing that documents could be executed electronically, as well as the entire transaction being conducted electronically. And for the sake of brevity and condensation, these two paragraphs, which I believe were towards the end of the old contract, are now one. So really nothing substantive happening here. Things are pretty much remaining at the status quo when it comes to electronic signatures and conducting the transaction electronically. And as you'll see here, provisions, the entire agreement provision, computation of days, seller responsibility, generally remaining the same. We've discussed tenant occupied addendum and leases that may be in place in general pretty extensively at this point, but of course, just another statement, seller representing that the property is not tenant occupied nor subject to any leases unless you have that tenant occupied addendum, an important document to attach again if the property is tenant occupied. And then again, provisions related to the non-assignability of the contract without the written consent of both parties to it. And we used to have a paragraph that was related to paragraph headings. Of course, now we've expanded that just to reference the fact that we also have section headings. So section 2, payment of the purchase price. You don't see anything highlighted here because we have just taken these provisions from the outgoing contract and put them in one section where they all make sense being near each other because they all relate to the payment of the purchase price. So you'll see very familiar language, the financing paragraph, the financing application and commitment, buyer responsibility, provisions pertaining to sale or settlement or lease of other real estate, and the buyer's right to pursue alternate financing if they so choose are still in here.
Right. I like the buyer responsibility paragraph being moved up there. That was a paragraph that we did have a decent number of questions about. If the buyer is denied for financing or something happens along those lines, does that mean the buyer is automatically going to get their EMD back? And their legal hotline responses, we would always suggest that the agent read the buyer responsibility paragraph. If the buyer has made any misrepresentations, then that's going to be a problem. They may not necessarily get their EMD back, even if they received a denial letter. So if you haven't read the buyer responsibility paragraph recently, take a look at it. It's important for listing agents to understand that, and obviously important for buyer's agents as well. But that's something that was sort of tucked away at the end, and I personally like it having a more prominent place in the contract now.
One could say, Kathleen, it may have been lost in the sauce.
One could say that.
I don't have any favorites when it comes to members, but one of our esteemed members on the statewide forms committee likes that phrase, and I like it too. And especially in the context of our contract, I was a first-time home buyer myself last year. And I remember there were a couple of points over the course of the transaction where I wanted to find something. I wanted to see where something was in the contract because I was sure that there was a provision about that. And things could be kind of hard to find because you had things related to transfer charges and mediation and buyer responsibility just sort of interspersed throughout the contract. And I think that really the section heading is one of the biggest changes, just the overall reorganization. Like you said, I think it's been very well received, and I think really makes all of the information just much more easy to find for consumers.
Definitely.
All right, shifting gears to section 3, property condition and inspections. A lot of changes here. I think perhaps Kathleen, maybe you'd like to talk about wood destroying insects to start off.
Yes, that is probably one of the more significant changes. And again, listen, everybody, this one is important. In the previous version of the contract, there was a wood destroying insect paragraph in there automatically, right? That was part of the contract. That has changed. This is, again, something the task force worked on, one of their recommendations, which was approved by the statewide forms committee, approved by the executive committee. The intent really is to really to have created a true as-is contract. And the discussion was, well, if they're, it's required to do a termite inspection, then it's not really as is. And everyone agreed. So the termite inspection, the wood destroying insect inspection paragraph has been removed from the contract, and it is now going to be part of the property inspection addendum. So if the buyer wants to have a wood destroying insect inspection done, they need to utilize that addendum. We'll talk with the VA in a second. That'll be another form we'll talk about. Yeah. One of the things, though, that people were often not aware of until a situation came up, in the previous version of the contract, the outgoing version of the contract, the sellers had agreed that they would pay up to 2% of the purchase price for any repairs that were required pursuant to that paragraph, pursuant to the inspection. And we did have a number of calls on the legal hotline where people were shocked that sellers didn't realize they had agreed to that. The listing agent maybe had not realized that that was in the contract. So I think removing it, it sort of makes more sense organizationally. Conceptually, it makes sense because we wanted it to be a true as-is contract, or as close to that as possible. So that is no longer in the contract. This is particularly important for VA buyers. We'll go through those addendum. We'll speak about the VA addenda in a minute. But just remember, a VA buyer does have the right to have a wood destroying insect inspection. To get the financing, they're going to have that. So that's going to be on the VA addendum. If the buyer, however, wants a chance to negotiate, let's say there's extensive damage and it's going to cost $10,000 to repair the damage. The buyer doesn't want to pay that. They would like to ask the seller to repair it or give it, a credit or whatever it might be. The buyer needs to utilize the property inspection addendum to have the right to negotiate. They have the right to have the inspection done pursuant to the VA financing addendum, but if they want to do anything beyond that, ask the seller to pay for anything or negotiate anything, they need to use the property inspection addenda.
Right. And you made mention of the VA a few times in what you just said. And so I think now's a great time to just talk generally about a big change in their policy when it comes to wood destroying insect inspections that came down on June 15th, 2022. So not too long ago. But what that policy essentially does is make it permissible for the cost of a wood destroying insect inspection and repairs to be paid by VA buyers. Previously, those costs needed to be borne by someone else. Oftentimes, agents involved in the transaction would pay for those inspection fees. Sellers would have to agree to pay for wood destroying insect remediation or repairs in order for the transaction to move forward. The VA has changed their policy, though, such that VA buyers now may pay for those things, i.e. negotiate the cost of those things. So I think that's a really important update. And as you'll see, we make reference to that in the property inspections addendum, as well as reference to that change in policy in the VA financing addendum, just so that folks are on notice of that, because that's been a long-standing policy, and sort of just, no one at the VA gave me a heads up.
The nerve.
Right. So one day it changed, and now it happened to occur in tandem with finalizing a lot of the changes to our form. So it worked out in that sense. But you'll see here in section 3, before we shift to property inspections and more substantive discussion about as is, you'll see in paragraph 24, inclusions and exclusions. It does directly reference the disclosure of inclusions, exclusions, leased items, and utilities addendum. So another reminder, if you will, to make sure you attach that form. The condition of property and possession, that of course has been streamlined significantly. Sellers shall still deliver possession of the property vacant, clear of trash and debris, broom clean, and substantially the same condition as existed on the date of contract acceptance. But otherwise, this contract has been brought much closer to a true as-is transaction. If no inspection addenda are going to be attached, this is going to be a true as-is transaction.
James, I was going to say in that paragraph, I'm sorry to interrupt, in that paragraph, just focus on the phrase, the same condition as existed on the date of contract acceptance. I'm always thinking of legal hotline questions that we've received.
I know exactly what you're talking about. Take it away.
The falling tree?
Yes.
Yeah. If, the date of contract acceptance, let's say, 2 weeks later, there's a hurricane comes through and a tree, falls over and lands on the house. The seller cannot say, the transaction transaction is as is. Sorry, buyer, you're going to have to deal with that tree. The seller has to convey the property in the condition it was, substantially the same condition as existed on the date of contract acceptance when the tree had not fallen on the roof. So the seller is going to have to correct that to restore it back to the same condition it was on the date of contract acceptance. That question has come up. I'm not saying there's trees falling down all over the place, but that question has come up more than once.
Right. So many times. And just that final sentence there, of course, buyer still reserves the right to do that final walkthrough within 5 days prior to settlement to confirm that that condition of the property is substantially the same as it was on the date of contract acceptance. But now let's not shift gears, but we'll direct the conversation towards inspections and the as-is addendum, which I mentioned earlier as being retired. For a number of reasons, and I'll probably call on Kathleen over the course of this to backfill a little bit more historical understanding for me. But generally speaking, in talking about the purpose of the as-is addendum, which was created, I think we've been consistently saying about 13 years ago in the aftermath of the Great Recession. So we're talking 2009 or so. That form was designed to allow a seller to convey a property just as the title says, as is, with no expectation that the seller was going to conduct any repairs or offer any credits. The property was going to be conveyed in the condition that it was, and for a number of reasons. And certainly when you think of the Great Recession, you think of short sales, the foreclosure crisis, circumstances that sellers may have been experiencing that really hindered their ability to do those sorts of things, to do repairs. And so by having that as-is addendum, it gave two real avenues. One was with no inspections and no right to terminate, which is essentially what our new contract is. If you don't attach a property inspections addendum, you're not getting any inspections or the right to terminate, which was subparagraph A on the outgoing to be retired as-is addendum. But subparagraph B was the one that we found in conversing with folks on the task force, as well as the statewide forms committee, as well as through our experience on the legal hotline. Subparagraph B was not being used for the purpose it was intended. Those of you who are familiar with that form, subparagraph B gave buyers the contractual right to conduct whatever inspections they wished, and once they had done those inspections, terminate the contract, again, if they wished, within a single agreed upon time frame, a certain number of days. Sounds great, right? But especially if, again, a seller is expecting to convey the property as is. Buyer has the ability to do whatever inspections they want. If they don't like the results of the inspections, they can walk away. Now, there was no contractual framework within the as-is addendum that allowed buyers to negotiate repairs. And yet, we would still hear instances of buyers communicating to sellers, well, we're going to terminate by the deadline unless you repair X, unless you offer us Y amount of money. Even worse, I would say, buyers submitting a property inspections notice to the seller together with inspection reports, when that document was only designed to work with the property inspections addendum, never intended to be used with an as-is addendum. Right. And really just that document just was not being used for the purpose it was designed for. Right.
I would say, James, not you had referenced earlier, going back to the Great Recession. More recently, where these abuses were taking place was the last year's market, especially the 2021, I would say, where there was a big shortage of inventory and sellers were receiving multiple offers. Buyers wanted to make their offers more attractive to a seller.
Look more attractive.
Right. So the thought was that you submitted an offer, an as-is offer, and that'll be more attractive to the seller. And the concern, of course, what was perhaps happening, the buyer may have had no intention to actually purchase that property, as is. So as James had just alluded to, after the inspections were done, rather than just terminating, oftentimes the buyer's agent would submit a copy of the property inspection report, making the seller and listing agent aware of certain issues or defects, and basically trying to negotiate at that point as if it was a typical transaction, not an as is. So we had a lot of discussions about that. We had a lot of questions on the legal hotline. This is not the way the form was intended to be used. Buyers are trying to take advantage, and the sellers didn't want to make these disclosures. It was causing big problems. So that was a large discussion in the task force. And again, the statewide forms committee, obviously everyone's been dealing with this for a while. So that was some of the considerations that went into play in modifying the form and getting rid of that addenda.
Right. And to talk briefly about the outgoing property inspections addendum as well, before we jump into the new form, I think the task force took a lot of aspects of that form into consideration when designing the new form. And one of those was the fact that each and every inspection that could be agreed to had a different time frame for conducting that inspection. And when you're trying to keep track of deadlines and due dates over the course of a transaction, really having all of those different deadlines and due dates for each and every different inspection, of which there could be many, to be conducted, I think was problematic, was considered to be problematic as well. There were a lot of, I think some, to a degree, extraneous language contained in the addendum that we'll talk about how and why that's been removed from the outgoing addendum. But with that being said, let's take a look at the new, I should say, property inspections addendum. So here we are. And going back to what I just said about each inspection having a different amount of time to be conducted, we've now gone to a single deadline. So in paragraph 1 here, the parties can agree to a certain number of days for which all inspections are to be conducted. And we have the list of inspections here. So of course we have structural, mechanical, mold, environmental, radon, chimney inspection, lead-based paint hazard inspection, wood destroying insect, as we've talked about previously, is now here, as well as space for additional inspections to be agreed to. Now all these inspections need to take place by that deadline date, that number of days that's indicated in paragraph 1. You will note that, for example, under structural and mechanical in the outgoing addendum, there were a number of different examples of what types of inspections could be considered structural and mechanical. I think the thing about that language that I caught on to pretty quickly, pretty early on in my tenure here as a staff attorney, was that it was preceded by the term including but not limited to, which really blows open the door to the different types of inspections that could be considered to be structural and mechanical. You could not look at that list and say, well, you can't do anything that's not on this list. It just didn't, the form was not written that way. So I think taking out that language, it really didn't operate as a restrictive measure, if you will, on the types of inspections a buyer could do. And you'll see a lot of familiar language here. Purpose of the inspection selected below is to discover unsatisfactory conditions, if any, of the components of the systems of the property. Future condition and performance is not warranted by the seller and not considered part of this addendum. And further, the inspections are not for the purpose of making items of routine maintenance and or cosmetic nature the subject of further negotiations between buyer and seller. Buyer's agents should not be listing cosmetic issues, cosmetic things on property inspections notices. In fact, the buyer has expressly agreed here that they will not do that. And this is made part of the contract, so something to really be cognizant of. Another thing that has come up a couple of times, if a furnace is old, if a heat pump is old, but it's working, it's old and it's working. There's not necessarily anything to repair. A buyer is not entitled to demand a brand new furnace. The furnace is old. They were aware of that. At the time they did the inspection, at the time they looked at the house, you go downstairs, you look at the furnace. I remember my own real estate agent getting down on his hands and knees and looking at the age of the furnace to tell me how old it was. And I was glad he did that, because when I was making my offer, I knew that the furnace in the front of my house was 18 years old and the heat pump back here in my guest house is 25 years old. I was on notice of that. I was able to take that into account when I was preparing my offer. But just by way of the age of the system, there's nothing in here that gives me a contractual right to demand a new one. so
Right.
long as it's working, so long as there's not a defect. Something I'm happy to say here, recorded for all of you all. Uh, but going a little bit further, of course, we wanted to emphasize when it comes to VA buyers, they need to retain the right to conduct that wood destroying insect inspection, because otherwise their VA financing is not going to be approved. And certainly, it's hard for me to foresee a situation where a VA buyer would proceed without attaching a property inspections notice, rather addendum. But of course, we wanted to state it here. It's also referenced in the VA financing addendum. But VA buyers, they're going to need that inspection. The change really is that they can pay for that inspection now themselves. And I do anticipate with the change in that policy, Kathleen, that the vast majority of VA buyers are going to be paying for the cost of that inspection now.
I would assume, yeah.
Mhm.
One thing I'd like to just let's pause for 1 second, James. Under the notes there, read the first sentence. Under the note, buyer's right to inspect or test well and or septic systems water quality and water yield shall be reserved through separate addenda.
Absolutely.
Those addenda exist now. It's important to remember that those are going to be separate timeframes. Those would not be included with this addenda.
Right. And those addenda, specifically, we're talking about the on-site sewage disposal system addendum. We're talking about the water quality addendum and the water yield addendum. Those documents, as Kathleen just said, great point. Inspections and tests pursuant to those items are through those forms and should be attached if necessary. Again, if a property is serviced by a well, has a septic system, etc. So shifting to the inspection process, I think now might be a good time to talk about briefly what was paragraph 4B in the outgoing property inspections addendum. Paragraph 4B was not used frequently. Oftentimes I've brought that paragraph up in other training sessions and folks don't know what I'm talking about. It was the boxed paragraph is usually the way
Right.
to get people to
One of the boxes.
recognize that. And if the
One of the
party,
boxes that no one read.
right. And if the parties agreed to that provision, the agreement within an agreement, I call it, that gave buyers with a property inspections addendum the unconditional right to terminate the contract simply by way of having conducted the inspections. They didn't have to provide the inspection reports to the seller. It simply gave them that unilateral, unconditional right to terminate the contract. That was very infrequently used. And as a result of that, if a property inspections addendum was attached to the contract, buyers did not have the ability to walk away from a transaction once they'd done their inspections, even if certain conditions arose. And the most common example that's usually referenced to me when I handle hotline calls in this regard is mold, extensive mold. Some buyers simply are just not interested in any sort of remediation or repair that a seller might be willing to undertake. They just want to get away from the property, walk away from the transaction. But buyers did not have the ability to do that. Instead, they would be forced to request repairs from a seller. And oftentimes, a strategy, if you will, for getting out of those sorts of transactions under the old form was to request a repair of every single defective condition, issue, malady, what have you, that may have been identified in a property inspections report, and send that over to the seller. And of course, a seller might say, well, I'm not going to engage in tens of thousands of dollars worth of repairs. Maybe I'll do X or maybe I'll do nothing, thereby then giving the buyer the ability to terminate the contract. But Kathleen, what does the seller now have? And what does the listing agent now have?
They now have information that they did not have previously.
Right.
The seller is required by law to disclose latent defects, which if they have a copy of that home inspection report in hand, they now have knowledge of latent defects that they may not have had previous knowledge of. And the listing agent, of course, is obligated to disclose material facts, which now having this report in hand, they now have knowledge of material facts that they may not have had knowledge of before. So that's the obligation to disclose has been broadened in that situation.
So that was a common issue that was raised to us and was sought to be addressed by this new form. So as you can see in paragraph B, subparagraph 1 here, the right to terminate if the results of an inspection are unsatisfactory to the buyer may terminate the contract of sale by delivering a unilateral notice of termination to seller by the deadline. Buyer does not have to specify the basis of their dissatisfaction, and that right to terminate it expires at the deadline. One question that we've both gotten, I think, with quite frequency is, well, what happens if the parties agree to strike that out? Well, you are then subjecting yourself to the situation that Kathleen just described in excruciating detail. If a buyer wants to get out of the transaction, you will be getting those inspection reports, and you will then be subject to whatever request the buyer makes. And if the seller is not inclined to repair what may be an extensive list of items, you're right back to where you started. The buyer has the ability to terminate the contract if they so choose.
Right.
Something to be cautious and aware about.
Right. And I just think, again, from the listing agent's perspective, if the seller asks you to strike through this and delete this, and the end result is that you end up and the seller ends up getting a copy of a property inspection report, this, we all know how this plays out. The seller is still not going to want to disclose those issues. If once the transaction falls apart, the property is listed again, they're not going to want to disclose those issues. They may be upset with you. Like, wait a minute, why did I get a copy of this report? How come you didn't tell me that I was going to get this? Now the next buyer is not going to offer as much money. You guys know this story, know this song very well. So I would say if the seller is asking you to strike that paragraph, or if you are thinking that it might be a good idea, speak with your office manager, your broker, and just, discuss with them and make sure you can explain to your client that it may seem like a good idea, but there are consequences.
Absolutely.
And that it may play out in a way that the seller's not anticipating.
Right. But of course, in the vast majority of transactions, the buyer is probably going to want to negotiate potential repairs. So in lieu of terminating the contract of sale, so if the buyer is not going to terminate, they then will put themselves down this path, the right to negotiate path. And once they elect to do that, that unconditional right to terminate, that goes away. Think of a fork in the road. You go one way or the other. If you terminate the contract, of course, contract is terminated, deal is dead, however you want to describe it. But if you then initiate the negotiation process, you are then bound by those terms that are set forth in paragraph B3. So the right to negotiate, again, in lieu of terminating the contract of sale in accordance with subparagraph 1B1, buyer may make that single written request for repairs. Again, we're contemplating that all of the inspections, they're all now on a single period, a time frame, a single deadline. So you make that request for repairs once everything is done, and you have the same amount of time to do everything. So if a large number of different types of inspections are required for a particular type of property, certainly can vary based on the location of the property, the size, what have you. Make sure you're building in as many days as it's going to be required to conduct all those inspections and get those inspection reports back, so everything can be put on that single written request for repairs. And of course, that right to negotiate repairs, as with the right to terminate, they both expire at that deadline. You have to do one or the other by the deadline. And certainly when you deliver that request for repairs, you have to deliver copies of the inspection reports that support those repair requests. And
James, let me just ask a question here. What might happen? I'm a buyer's agent. There are going to be 4 inspections done. I don't know. Chimney inspection is going to be done. Wood destroying insect. The chimney comes back first, and there's something bad with the chimney. I'm so outraged by this terrible condition. I send over a request for repairs just addressing the chimney.
Don't do that. Please don't do that, because you only get one shot at it. The idea is that you are waiting, that you are completing all of those inspection requests, and you're not sending multiple. There's no need to send multiple repair requests, because everything is operating under one deadline. So you have to conduct all of those inspections by that deadline, and in turn, any repairs for requests that you're making pursuant to all of those different inspections find themselves on one single written request for repairs.
Right.
Great question. Putting your agent,
anticipating something that might happen.
Your
One
member-
shot. You get one shot. Don't throw away your shot.
Exactly. Seller's response. So I think there's going to be a lot of familiar language in here as well. We have very similar framework for timeframes, at least, for negotiating these repairs. So within 5 days after buyer delivers that written request for repairs, seller shall notify buyers in writing whether the seller is going to agree to all, some, or none of the requests. Now, of course, If a seller agrees to do everything the buyer requests, you're done. The contract remains in full force and effect, and things move on to settlement. Seller then engages whatever contractors are necessary to conduct the repairs, gets receipts, presents them to the buyer. Everyone's happy, right? In most cases. So, but
We
of
never
course,
hear about those on the legal hotline, by the way.
and I may not have answered a question this morning about what happens when a seller does not provide those receipts. But anyway, of course, if a seller does not agree to do everything that the buyer requests, then there's some choices. So seller has 5 days to provide that response. If the response is they're only going to do some of the changes, or perhaps instead offer a credit, or indeed do nothing, they're not willing to do anything, buyer has 2 days from receipt of that notice from the seller to terminate the contract of sale, waive their repair request essentially and proceed, or take what the seller is willing to offer, or terminate the contract. I may have said one of those twice there. But what we'll do is we'll shift over to the property inspections notice, which I think lays out all of those choices really nicely with check boxes. We've also built in, and I'll mention this briefly, the ability to conduct some additional negotiations. So previously, as I just said, buyers had a limited scope of options, essentially accept whatever the seller was willing to offer, or terminate the contract. That was the last step, and there was really no contractual framework for negotiating anything beyond that. Now there is a limited ability for buyers and sellers to make some more counteroffers when it comes to negotiating a final agreement as to what a seller is willing to repair within a 2-day time frame. So there's 2 days back and forth. One thing I will caution, though, let's say buyer gets seller's response. Seller is willing to do a certain scope of repairs, not everything the buyer requested. Buyer does have the ability to kick it back to the seller, if you will, say, well, you won't do everything I requested. You're only offering to do this. Will you just do these couple of extra things? They can do that, but bear in mind that the seller, in response to that, could say, you know what, I'm tired of dealing with this buyer. They're asking for too many things. I'm going to terminate the contract. So make sure that you're reviewing subsection B3 and B4 carefully, just so that you have a complete understanding of how that process will go forward. And certainly if you are working with in the midst of a transaction, make sure you're calendaring these deadlines so that you are aware of, okay, when should I be expecting a response, as well as, oh, my client needs to provide a response to the other side. What's the absolute drop dead deadline that needs to be provided?
Right.
So let's shift over to the property inspections notice, which I think really sets forth that process very succinctly. And you'll see a lot of familiar content here as well. So of course, identifying the types of inspections that have been agreed to, and then that initial notice to the seller from the buyer, which we're all very familiar with space to indicate what repairs the buyer is requesting, as well as, you know, if you need additional pages, you can certainly attach additional pages. And then again, very familiar, the response from the seller to the buyer. They're going to agree to complete all the corrective action, in which case no response from the buyer is required. The seller's not going to do anything. The seller's going to do some things, not everything, as well as the option for the seller to agree to credit buyer a certain amount. And that seller contribution addendum, of course, is still in our statewide forms library. Where things have adjusted in some way, in a minor way, I'll say, is the response from the buyer to seller, in that there is now an additional option. So previously, buyer accepts seller's response and waives corrective action of any unsatisfactory conditions seller will not complete, and or buyer accepts seller's offer of a credit. Buyer terminates the contract in accordance with the provisions of 1B3 of the property inspections addendum. So they, of course, retain that ability to terminate the contract, as we've discussed at some length today, if the seller is not going to agree to do everything the buyer requests. Now we have another or. So buyer proposes a counter offer to seller's response to their initial request for repairs, and that counter offer can be stated here. You know, in addition to what seller has agreed to do, buyer requests that seller do X and Y, for example. And then there are a couple of more spaces for back and forth, but note that, buyer could terminate seller could terminate the contract in response to buyer's counteroffer. And then, of course, where things land, at least on the property inspections notice, we did not want to go page after page after page with these offers. Buyer can, accept the seller's latest counteroffer or terminate the contract. So I think that, this just gives a little bit more flexibility for agents who were looking to have a place to express written negotiations. I know a lot of times, especially when within these timeframes, negotiations happen in the background, and that is okay as long as the full and final agreement is distilled to writing. But certainly, previously, things cut off here with paragraph 4. You had options A, B, and C. There was no counteroffer. Buyers had this limited scope of options. There was no framework to negotiate anything further. And now we have a little bit more flexibility in that regard.
Right. I think in general, I think what the feedback that I've received is favorable for this. And I think from what most people have said, this is actually consistent with what was happening anyway. And then you were put in a difficult situation to try and draft an addendum to address that, or extend a time frame, or deal with it in some other way. So again, with a very important feedback from the statewide forums committee, this process was put in place here to reflect what actually happens in reality. And again, give those stopgaps that James just pointed out, when the parties would still have the right to terminate moving through this process.
Absolutely. So just to round out the property inspections addendum, really briefly, of course, provision if either party elects to terminate the contract in accordance with the terms of the addendum. And bear in mind, in the property inspections notice, if a buyer or seller is going to terminate, they have that option at whatever stage they're at. They really just need to select that, this one. They would select this box or whatever applicable box. There's no need for a unilateral notice of termination if you're operating under these provisions of the property inspections addendum and notice. You would need that unilateral notice of termination if you're going to exercise that right to terminate instead of requesting repairs, because of course you're not sending a PIN. You're a property inspections notice rather. You are just terminating, and that unilateral notice of termination is the form to use to do that. But yes, all deposits would be dispersed in the event of termination in accordance with the deposit paragraph of the contract, which we've talked about. And then again, a lot of very similar carryover language regarding the rights and obligations of buyers and sellers. Again, another instance where things have really not changed that much. I remember we've gotten a couple comments regarding sellers being present during home inspections. Look, perhaps not something a seller would want to do, because then they're on notice of certain facts about their home that they might not want to be on notice of. Same goes for listing agents. But that's something the seller is certainly entitled to be in their house during that time if they so choose. There's nothing to prevent them from being there. It's their house after all. So
that's old language. That's not new language.
That is old language. Something to be mindful of as well. And certainly making sure that buyers giving seller reasonable notice of the date and time of inspections, not texting the listing, hey, we're on our way, just wanted to let you know we'll be at the house to inspect in an hour. Get out of the shower. But yeah, things. Another example of things that have not changed. And then certainly the seller's obligation to complete the repairs they say they're going to complete, and provide receipts in sufficient time so buyer can take another look prior to settlement. All right, so I think that rounds out the property inspections addendum, unless Kathleen, anything to add?
No, I think that's it.
All right.
Thorough discussion.
Right, so we can circle back, and of course, if an inspection addenda, if any inspections are going to take place, including on-site sewage disposal system, water yield, or water quality, you're going to initial here. The buyer's going to initial here, rather, inspection addenda attached. If none of those things are happening, which I imagine would be an extremely limited scope of transactions, but certainly a possible, inspections declined. Continuing forward now, I won't. I will say this is a part of the session where you're going to see some fast forwarding, if you will, because the main thing to understand here is that a lot of the content in sections 4 and 5, property specific disclosures and general disclosures, respectively, has remained the same. It's just been pulled from other parts of the same contract and condensed, consolidated into their own sections. So I'm not going to read through each of these paragraphs. This is not reading with realtors, but I just want to point that out to everyone. Look, you're going to see a lot of familiar provisions here. They're just in a different place. There was an adjustment made to this paragraph, which previously only referenced homeowners associations, but now also makes reference to condominiums. Again, we kind of talked about this a little bit at the outset with that new condominium and homeowners associations forms practice guide. But if the property is subject to an HOA or a condominium regime, there's a whole other set of forms that need to be attached to the contract of sale, made part of the contract of sale, so that both parties can comply with the provisions of the Condo Act or the HOA Act as applicable. But going forward, and in section 4 here, we have the notice regarding disclosure of deferred water and sewer assessments, provisions pertaining to agriculturally assessed property, conservation easements, forest conservation management program, and the Forest Conservation Act notice. Again, these are provisions that have been in our contract and are just remaining here in another section.
I'll say, James, one question that I was asked was someone wasn't clear on what the distinction was between section 4 and section 5 with respect to disclosures. Section 4 that we just went through, those are really disclosures that are specific to that property. Is this property subject to deferred water and sewer charges? Is this property agricultural easement? Is this property a part of a condo or HOA association or regime, excuse me? The section 5 is more general disclosures, typically things that would be disclosures that are required to be made under state law or federal law, sort of more general disclosures. Section 4 is specific and unique to that property.
Right. That's a great way to explain that one. And indeed, the very first provision in section 5, general disclosures, is pertaining to that residential real property disclosure and disclaimer statement. One thing I'll note here briefly, the form that we have from the Maryland Real Estate Commission combines disclosure and disclaimer. What I mean by that is a seller is, of course, going to either disclose or disclaim. If they're going to disclose, they need to fill out the first 3 pages of that form and sign at the bottom of page 3. If they're going to disclaim, they fill out the property address at the very top of page 1, and then skip down to page 4, indicate whether or not there are any known latent defects, and sign at the bottom of page 4. Oftentimes I'll see forms, so I do go into Bright MLS for fun sometimes. I'll see forms that have been completely filled out, page 1 all the way through page 4. Sometimes they'll fill out pages 1 and 2, and then, oh, I made a mistake, they'll skip, down to page 4, or very inconsistently filled out. And really, it's just one of 2 ways to fill it out. When you're either disclosing or disclaiming. Even more critically, though, of course, listing agents need to make sure that sellers do fill out that form one way or the other, whether they're going to disclose or disclaim, and that form is available to buyers as they are making, prior to making an offer on the property. Because if a buyer does not have that form in hand at the time of making an offer, that makes any contract that is formed voidable. Not just until the point where a buyer eventually gets that form, but for 5 days after that. And that can certainly put a listing agent in hot water, even potentially a buyer's agent, because buyer's agents should also be saying, where's the disclosure and disclaimer statement? So, make sure that form is uploaded to Bright as part of your listing process, and buyer's agents make sure that form is available to the buyer. Make sure you're pulling it from Bright, or if necessary, asking the listing agent for it before your buyer makes that offer.
All right. I was just going to say, James, we have a different definition of fun. I do not scroll through Bright looking at disclosure disclaimer statements for fun.
That's fine.
All the points that you raised, though, are good points, and we have been asked questions about them. The form should be completed properly, and as James had said, the listing agent should have it up on Bright before put it up with the listing as the property is listed. If you fail to do that, you potentially have, put yourself at risk, put your seller at risk, because the buyer does have rights. And if you guys have taken the brokerage relationship and disclosure class in there, there's some information on there, some FAQs talking about that. The buyer's agent should not have to call and follow up and ask for it. And where is it? Are you going to upload it yet? There's the real estate commission has some thoughts on that. Let's just leave that alone there.
But going forward, ground rent provisions pertaining to ground rent. Lead-based paint. I did get a couple of questions in this regard. Do you still need to include the lead-based paint disclosure document with this language in here? This language has always been in the contract. And yes, that disclosure form still needs to be filled out. Now, I will periodically get calls on the hotline. Well, the property was built in 2000, and yet the brokerage on the other side is requiring that my seller sign this form. The reality is that the form is only required, the disclosure of the federal lead-based paint disclosure form is only required for properties that were constructed prior to 1978. If it was constructed 1978 or later, it's not required. That may be something that a brokerage requires internally, but there's no legal basis for that requirement. Just want to make that clear. But of course, this language here is in the form of a notice, a disclosure, if you will, to put parties on notice of these requirements at the federal level, as well as the Maryland Lead Poisoning Prevention Program, which again is another form that we have in our statewide forms library, really meant to put buyers of properties that may currently be rented on notice of the fact that those properties should be registered, and if it's in fact rented, lets the seller indicate whether or not the property has been registered with the state program. But not a required form for each and every transaction. Provisions pertaining to limited warranty here in paragraph 37, we really just updated this paragraph to reflect the title of this brochure that we offer, as well as a link to that brochure talking about property insurance, flood disclosure notices, and information about the guarantee fund administered by the Maryland Real Estate Commission, notice to buyer concerning Chesapeake and Atlantic coastal base critical area, wetlands notice, criminal activity. Again, I'm fast forwarding a little bit because these provisions have been in our contract. They work well, and they were just consolidated into this general disclosures section of the contract.
And just a reminder for the contract, as we're scrolling through the contract, the changes have been highlighted. So as we're going through paragraphs and you see they're not highlighted, that's because the paragraphs themselves have not changed. The verbiage is the same. Their location may have changed, but the substance of those paragraphs has not changed.
Exactly. Into section 6 now. Again, a lot of language that has remained the same, but some substantive changes here that we're going to discuss. Of course, notice of the buyer's right to select their settlement services providers, which is governed by statutes. Buyers are entitled to select their own title company, mortgage lender, any settlement service providers. That's their statutory right. The deed and title paragraph has remained the same. Paragraphs relating to adjustments, payment of settlement costs. In our contract of sale, the buyer agrees to pay all settlement costs and charges. Indeed. But moving along to the big change here, paragraph 51, talking about transfer charges. So I just want to discuss at some length, to be honest, what the law in Maryland is about transfer charges and what our contract of sale has done and continues to do regarding transfer charges. So the law in Maryland when it comes to transfer charges, and by transfer charges, I mean state transfer taxes, local transfer taxes, and local recordation taxes. What state law says is in general, and when I say in general, I mean residential real estate transactions where the buyer is not a first-time Maryland home buyer. So in general, those transfer charges are going to be split equally by the buyer and the seller. So buyer and seller will each pay 0.25% because the state transfer tax in total is 0.5%. They're each going to pay 0.25% in state transfer taxes, and then whatever the local jurisdiction calls for in terms of local transfer taxes and local recordation taxes. And that's what our contract said. Statute said everything is split equally. Our contract said everything is split equally. So previously in our old outgoing contract, there was nowhere for the parties to express a different agreement, which is permitted under the statute. The parties can agree, for example, that the seller will pay all transfer charges or that the buyer will pay all transfer charges. There was nowhere for that to be expressed. And now there is a space for that to be expressed if the parties so choose in the body of the contract. Certainly, if there is to be no agreement other than an equal split of those charges, that box can remain blank, or you can put NA, N/A, not applicable. I know many people are more comfortable with that. That's totally fine. So that is, in general. Shifting to first-time Maryland home buyers, which I was one last year, so I can speak to this some firsthand knowledge. What the statute in Maryland says, what Maryland law says, is that the seller is going to pay all local transfer and recordation taxes. They're also going to pay their portion of the state transfer tax, with the buyer's portion of the state transfer tax waived in its entirety. So the seller's paying that 0.25% of the state transfer tax. They're also paying all local transfer and recordation taxes. Okay, that's what Maryland law says. But what our contract of sale has said previously, and what it continues to say now, is something different. Because again, like I described before, Maryland law allows for a different agreement. It allows for the parties to agree to something different.
Right.
And what that different agreement is that when a first-time Maryland home buyer is involved in the transaction, the parties split all transfer charges equally. That means that the buyer, their portion of the state transfer tax is waived, but they're going to pay half of the local transfer taxes and half of the local recordation tax. And the seller pays the remaining. So they pay their portion of the state transfer tax, which is not waived. It's 0.25%. And they pay their half of the local transfer and recordation taxes. Now, the purpose of our first-time Maryland homebuyer transfer and recordation tax addendum, which has been retired, was to express a different agreement because we didn't have a space in the contract for that to happen. So there were options for the seller to pay all, the buyer to pay all, etc. One thing that is worth noting is that the seller is obligated by statute to pay their portion of the state transfer tax. The statute says that portion shall be paid entirely by the seller, and that is statutory. There's no way around the word shall. But in an effort to, again, streamline our forms and the language in our contract, we've removed some of the statements of law that used to be contained in the transfer charges paragraph, which for those of you who recall was in old paragraph 25. We're now in paragraph 51. We've removed the statements of the law because we want to make it clear what the parties are agreeing to. And in both cases, it is indeed an equal split of all transfer charges. We do recognize here that of course, the buyer in a first-time Maryland homebuyer situation, their portion of the state transfer tax is waived entirely. The seller pays the 0.25%. Now, if the parties in the situation of a first-time Maryland homebuyer transaction want to agree to something different, there is space to express that different agreement. Of course, you also want to check the box on page 10, first-time Maryland homebuyer, because you want to put settlement services providers on notice of the fact that other documents are going to have to be prepared, specifically the affidavit the buyer signs stating that I am a first-time Maryland home buyer. I'm going to be occupying this property as my primary residence, etc., so that they get the benefit of the waiver of that 0.25% of the state transfer tax. But otherwise, I think that this is definitely a huge step in the right direction in terms of updating this language and making it more clear to both our members and our consumers.
And the first-time homebuyer addendum, the version that existed previously, that has not really been, if everything's going to be split 50-50, that was not necessary for several years, quite frankly, and people were still using it. They were using the addendum and saying everything was going to be split equally. We heard many complaints about that. Why are people still using that addendum? There's no need for it. So that was another one of the factors that went into consideration when we were revising the documents. And that form, many of you will be happy to know, that form is gone. No more first-time homebuyer addendum. All of that is going to be in these paragraphs right here that we just went through.
Exactly. So to round out the remainder of the changes to the contract of sale, Paragraph 52, we've just put folks on notice. There's information regarding what may be owed by a Maryland non-resident seller, specifically that withholding tax. We've updated the phone number and website where additional information is available.
Yeah, I would just say this was
Yeah,
something we had. Remember, we had a title company guy leading the task force. This is especially important for listing agents to be aware of. The seller, if they're a non-resident seller or an entity, if it's an entity that's not authorized in Maryland, the title company is obligated to withhold the taxes. This highlighted language here was added to make the seller aware that they can apply for a full or partial exemption. And they apply through the comptroller's office. And from everything I've heard, the comptroller's office is very efficient and actually will get this done as long as it's requested at least 21 days prior to settlement. The title company will receive, or the seller will receive a certificate from the comptroller's office. They would provide that to the title company, and it could say that they are fully exempt and that your sellers will love you because they will walk away from the table with more money, right? So just, if you're the listing agent, especially walk your seller through that. If they're a non-resident, make them aware that they may be entitled to get the full or partial exemption. If they can get this handled before settlement, it literally will affect the seller proceeds. They'll walk away with more money and they will be quite happy with you.
sure. Bear in mind, though, that the scope of exemptions is extremely limited. One of the most common ones I think is worth noting is a 1031 exchange. If your seller is interested in engaging in a 1031 exchange, this withholding will not take place. Instead, it gets kicked down the line to the next potential transaction. So just bear that in mind as well. Again, a lot of familiar provisions to our members who have experience with our outgoing contract. Some language changes to property owner's title insurance paragraph. Of course, we encourage buyers to purchase owner's title insurance, coverage afforded. So I think making it clear that policies issued to lenders don't necessarily, they don't protect buyers from losses caused by title defect. They need to have their own. And certainly that brokers don't warrant the condition of title, and holding brokers harmless from any damages sustained by buyer that may result from a defect in the title. Also important to read this in concert with the deed and title paragraph that addresses the existence of title defects and how those are handled specifically. Next,
I'm a big fan of title companies. I just say if your buyer client has any questions about that, well, I'm purchasing lender's title insurance. Why doesn't that cover me? Or are you sure that doesn't cover me? Reach out to your title company. Your title company can explain that in more detail to your client if they're confused or have any more detailed questions. But the main concept is that the lender's title insurance does not cover your buyer, does not cover the owner.
Exactly. Briefly, Section 7. All of our provisions related to breach of contract and dispute resolution are now in one section. I think that makes a lot of sense. So what constitutes a default, how disputes are to be mediated. We still have that mediation provision in our contract. So prior to initiating any legal action in connection with disputes or claims that arise prior to, during, or within 1 year of the actual contract settlement date or when settlement should have occurred, such disputes or claims are first subject to mediation. Of course, we have that in there as a way for the parties to craft their own resolution potentially to those sorts of disputes rather than leave it up to a fact finder, i.e. a judge or an arbitrator potentially. But that provision is still in our contract, as well as provisions related to attorney's fees. The last thing I really wanted to bring attention to that changed in our residential contract of sale is the addition of a definition of the date of contract acceptance, which is the date on which all final initials and signatures of all parties have been affixed to the contract. That phrase, that term contract, of course, is inclusive of any addenda that may have been made part of the negotiations leading up to the point that it becomes a contract. With that all said, Kathleen, anything before we shift gears to the other documents?
I think that's it.
All right.
Shift away.
Shift. With our remaining time, I thought we would go through some of the other new and updated documents that we have for 2022. We have discussed the disclosure of inclusions, exclusions, leased items, and utilities addendum. We've talked about property inspections addendum and property inspections notice. briefly discuss the additional as-is provisions addendum. Now, I think this is a document that's really going to see a very limited scope of use because it's really intended to be used in connection with distressed properties, if you will, foreclosures, estate sales, perhaps short sales. And I think the most common provision in this document that will be agreed to when it is used in those limited circumstances is this one. So by initialing next to these items, the parties are agreeing to delete from the contract of sale these particular provisions. And subsection A here would delete all clauses in the contract of sale pertaining to delivery of the property free and clear of trash and debris and broom clean. Now, this was part of our outgoing retired, that is, as is addendum. So if there is furniture in the property that the seller is not able to remove, or the seller is just not in a position to convey the property free and clear of trash and debris and broom clean, the parties can agree to waive that requirement, to strike that requirement from the contract of sale by way of subparagraph A. Now, subparagraph B and C, I think are going to see very extremely limited use, although it may be useful. And I again imagine this form as something that a seller is going to upload to Bright, because it's really the seller that is going to need the benefit of these provisions at the end of the day. But B discusses that all requirements for the seller to comply with orders or notices of violations in connection with a condominium regime or an HOA related to the physical condition of the requirement of the property are waived. So deleting those requirements, it does not constitute a waiver of any obligations of the seller pursuant to the Condo Act or the HOA Act. So the seller still has to deliver the required documents and information. The buyer still has the ability to terminate based on that information. But for example, if you are in a HOA and the shed in your yard is not painted the appropriate color and you've received a violation notice about that, the seller has rather, so long as the HOA does not have something in its bylaws, perhaps prohibiting the conveyance of the property with that in place, it is possible to agree that the buyer will take that obligation in hand, and the property can still transfer. Similar provision here for violation notices issued by governmental authorities. In my previous life as a judicial law clerk in the Circuit Court for Montgomery County, we've routinely heard cases dealing with property condition violations. So think garbage, debris strewn across the front lawn in violation of a local ordinance. Those cases would ultimately, if buyers, or rather if homeowners did not comply with those violation notices, they'd make their way up to court. So notices like that, if those have been issued, the parties agreeing that the buyer will resolve those notices. Now, if anything we've talked about here manifests itself as a lien against the property eventually, which can be the case, this is not going to save you from that. So that's going to be a title defect. So again, I think go ahead, Kathleen.
No, I just to chime on to that, I was just going to point out one question that I had been asked about subparagraph B. That is limited to violation notices related to the physical condition of the property. Someone had asked about assessments. If the owner's behind on their assessments, does this mean the owner does not have to pay those and the buyer is going to be responsible for that? It does not mean that. This is just talking about physical condition of the property. As James had said, if the deck or the shed is painted the wrong color, the mulch isn't properly placed around the tree, those type of things, the seller would not have to correct those violations. The buyer would be purchasing subject to and with knowledge of those violations. It does not relate to assessments or financial obligations.
Yeah, those law firms the collections divisions will still go after the seller.
Yeah.
All right, so moving forward from this, just to bring to everyone's attention, we've talked about this previously, but the VA financing addendum, just note that we have added reference to that updated VA policy here, as well as a link to that policy in black and white, so that parties to these contracts reviewing these agreements can access that and see that that policy has in fact changed. Briefly want to talk about disclosure of ATU BAT on-site sewage disposal system. So this is only a form that's going to come into play if a property has a septic system, and in fact a septic system that is of the ATU BAT. And when I say ATU, I mean aerobic treatment unit, BAT, referring to best available technology system. Now, those systems have been increasingly common in the last, I'd say, 7 years or so, really in the Chesapeake Bay critical areas. And these systems just do a better job of removing nitrogen from the septic effluent before it reaches the Chesapeake Bay and has adverse impacts on the wildlife in the bay, in particular, causing those algae blooms that deplete the blue crab populations. So, this form is designed to comport with Maryland regulations that require a certain degree of testing and maintenance of these particular types of systems. And essentially, this form really just contains the regulations. It also has a link to a list of certified service provider companies that are able to conduct these annual services of these systems. Indeed, homeowners themselves can become certified to do the system service themselves. But the form also requires that sellers, within a certain number of days of the date of contract acceptance, deliver to buyer any system documents and records that they have in their possession, inform the buyer of the name and contact information of the service provider they've had servicing the unit, as well as notify that service provider that the property is being sold and the name of the buyer.
Right. I would just say the practice tip for that, for listing agents, you may want to maybe bring this form with you or share this form with your seller during your listing appointment. Some people are good and organized with their paperwork, some maybe not so good. So it probably would be good to give the seller a heads up that the seller is going to have to provide copies of those documents to the buyer. Just a suggestion, you might want to go through that and discuss that at the listing appointment so the seller has time to gather the documents and will be able to provide them to the buyer within the agreed upon time frame.
Exactly. Over to the post-settlement occupancy agreement. This is a form that's been requested many, many times, I think, over the last few years, and we are now pleased to be able to offer it. I will just talk briefly about this one. In terms of the term of occupancy, and bear in mind, this is not a lease agreement. What this is a buyer granting a seller a license to remain in the property post-settlement for a period of no more than 60 days. And the 60-day time frame is significant because when buyers are purchasing properties, getting those properties financed, typically they are affirming that they will occupy that property as their primary residence, if they're purchasing it as a primary residence, within 60 days of settlement. So we did not want to create a form that permitted post-settlement occupancy beyond 60 days because we did not want buyers who are affirming they're going to be in the house within 60 days on one hand, committing perjury by letting a seller stay in the house beyond 60 days. So that's where that 60-day time frame comes from. If something longer than that is required, buyers may do well to consult with their lenders to ensure that something like that would be permitted, or they may need to consider a different arrangement with the seller. Perhaps a lease agreement would be more appropriate. But we do have this, again, this form is now available as of October 1. There are different ways that a buyer may be compensated by the seller for this. Nominal consideration, lawyers speak for gratis, free. There is also the option that the seller would pay the carrying costs of the buyer in connection with the property, as well as a flat daily rate, as well as provisions pertaining to security deposit, that security deposit is going to be maintained by an escrow agent, a third party. Conditions pertaining to property condition, that the seller is to pay utilities through the last day of the term of occupancy, and then a framework for conducting a final inspection of the property, noting any deficiencies that may exist. So any damage that was in fact caused by the seller during the term of occupancy. Really important if post-settlement occupancy is going to be conducted. We do have a final inspection walkthrough form. So prior to settlement, you're going to want to note what the condition of the property was so that you have some record of that to compare to what the condition of the property is at the end of post-settlement occupancy. A framework for the disbursement of the security deposit, a place for the escrow agent to agree to maintain that security deposit. Keep in mind that parties to a contract, so let's take me and Kathleen, for example, we cannot contract between ourselves that Chuck Caskey is going to mow Kathleen's lawn every other month.
We can't?
No, we can't. I'm sure Chuck is devastated. We cannot do that. So we cannot bind him as a third party in an agreement between the two of us. And that also speaks to the escrow agreement that we were talking about for purchase contracts. You need to have an agreement between the buyer and the seller. In this case, in connection with the post-settlement occupancy, the buyer and the seller and whoever is going to be holding that security deposit for the term of post-settlement occupancy. And there's a place for that individual to sign here within the post-settlement occupancy agreement. And then finally, the ability of the buyer to access the property during the post-settlement occupancy term. The express fact that we're not creating a landlord-tenant relationship here. This is not a lease. Again, not a lease. Provisions pertaining to the insurance that should be maintained on the property during the term of post-settlement occupancy, and then places for everyone to sign. So just wanted to make everyone aware of the availability of that form, and there is additional information in our manual of changes and practice tips. Just to round out, I want to get to the substantive changes before we run out of time. There have been a few minor changes to the FHA and USDA financing addendum. Specifically, we're just talking about the fact that we've changed what may have been referred to the termite inspection paragraph to wood destroying insect, just to be consistent amongst those different addenda that reference those. You'll see the same change in the USDA financing addendum, just referring now wood destroying insects rather than just termites. The conventional financing addendum, just want to make sure I can touch on that. At the end of paragraph 7, the appraisal contingency paragraph, we added this language, essentially referring to if a property fails to appraise, buyer may request of the seller that they reduce the purchase price to the appraised value. If seller declines to reduce the purchase price to the appraised value or fails to respond to that request, buyer has two options. They can declare the contract null and void, or they can agree to purchase the property at the purchase price, notwithstanding the appraised value. What we didn't have before was any thing to happen if the buyer didn't do either of those things. So essentially things were kind of left in a state of limbo if the buyer did not make one of those elections. So very important if you're dealing with an appraisal issue with the property pursuant to this conventional financing addendum, ensuring that the buyer makes one of those two elections. We have added the language that buyer's failure to provide that written notice of their election within the agreed upon time frame, which is here at the top of the subparagraph, is going to constitute the buyer's agreement to purchase elect to purchase the property at the purchase price. So keeping the contract in play is what the default would be if buyer fails to make their election based on the seller's declination to reduce the purchase price to the appraised value.
Right. Just another example, I think, as we pointed out throughout this discussion, pay attention to the timeframes, pay attention to the deadlines. If your client wants to get out and is not willing to purchase at the original price, you need to make sure that you respond.
Right. And just a few more forms to touch on. So this is a brand new form, our change in terms addendum to brokerage agreement. There was some feedback from members that there was no way to modify certain aspects of a brokerage agreement. Most common complaint, if you will, was there was no way to extend the term. So we created, rather than a different form for each brokerage agreement, of which we have 4, we created one form that can be used for each of those brokerage agreements. So our exclusive buyer tenant, right to lease, right to sell residential, and right to sell unimproved land. You would check the box that the brokerage agreement, that this change in terms addendum is going to be applicable to, state the name of the client, and you'll see we use the word client instead of buyer and seller. Client encompasses both, or tenant and landlord. Client encompasses all of those. Of course, you're not going to identify the property if this is to change an exclusive buyer tenant residential brokerage agreement, because of course you haven't identified the property yet necessarily. And then the options. So to extend the brokerage agreement term, to adjust the listing or lease price, as well as a space to express a different change if necessary. And of course, you should only be filling out and executing this document if you are an authorized representative of your broker, you've been authorized to do so, or if you are, of course, in fact, the broker of your company. Moving forward to our exclusive right to sell residential brokerage agreement, I am going to go all the way down to the bottom because we did an update to the very last paragraph, making sure that we included the disclosure of inclusions, exclusions, leased items, and utilities addendum as one of the addenda that may be made part of this brokerage agreement. One thing I do want to point out here, it's come to my attention that some folks use this paragraph as a checklist of sorts for all documents that they may need to list a property, and this is not that. By way of checking these boxes, you're actually making those documents part of the brokerage agreement, which is a contract. And in the case of the disclosure of inclusions, exclusions, leased items, and utilities addendum, essentially what you're doing is saying, we're making this part of the brokerage agreement. I'm going to accurately represent everything that you have disclosed here, which should be easy because you're really just uploading that document to Bright. But bear in mind that this is not an exhaustive list of everything you might need to list a property. And in fact, by attaching these documents, you're making them part of your contractual agreement by way of an addendum. Let's see. I will just point out briefly that our unimproved land contract of sale, we have not made substantive changes to this document, only insofar as we made changes to the residential contract of sale that were that involved provisions that were also applicable to the unimproved land contract of sale. But we did reorganize things by sections. And again, if the content contained in here was specific to unimproved land, that has not changed at all. We have just reorganized it so that it somewhat mirrors the residential contract of sale. For those of you who are familiar with both contracts of sale previously, you would notice that those documents did mirror one another. You would see similar paragraphs in similar places where applicable to both types of contracts. But we did just want to make sure that that consistency was maintained between the two documents. And finally, Kathleen, do you want to roll out our other new form for everyone?
Yes, thanks, James. This is our first commercial form that we have developed. And this was done, we have a committee, a commercial alliance, and the members of that committee had requested a listing agreement, to be used in commercial transactions because we did not have such a form. Some of the local boards did, but Maryland Realtors had never done that. And at the urging of the commercial alliance, the statewide forms committee did adopt and approve a commercial listing agreement. And the executive committee, same process as normal with our typical forms, the executive committee approved that as well. So this again would just be used for your commercial agent or a commercial transaction. You would use this as your listing agreement. There's the listing agreement itself, and then there's a statement about the commission. That's going to be included on there as well. There also is one addenda to it where the client is going to specify, inclusions, exclusions, information about utilities, leased items, things along those lines. So it's pretty straightforward. I just think there was a demand for it from our commercial practitioners, and we are delighted to be able to be offering commercial forms for the first time. So you'll see those on our website, commercial listing agreement, and the exhibit to it to discuss the specific items that are included, excluded, leased.
Yep, addendum A. And
Yep.
of course, re-emphasizing that if you have not engaged in commercial transactions before, let's ensure that we're able to do so. Some brokers, of course, you provide your real estate brokerage services on behalf of your broker. So discuss the potential for commercial listings with your broker first.
Yes.
And certainly, if necessary, partner with another experienced agent who has background in commercial transactions, because those are a different. Someone said it's a different ball game. I said it can be a different sport entirely. The nature of those transactions can be very different from residential, and so make sure you are proceeding with caution and with someone who has that expertise who can guide you through that sort of transaction.
Or I will always say there's no shame in making a referral.
Referrals are also great.
Yes.
Love me a good referral. So.
Yep.
All right. That being all said, I think that was a pretty comprehensive look at this year's 2022 statewide forms changes. I we thank you so much for your time and watching this video. Kathleen, was there anything else that I was remiss? Did I miss any?
No, no, I think we were very thorough, and I appreciate your time, James, and I hope our members do as well. Just a reminder, everyone, we do have a legal hotline. If there are any questions that come up, about this video, about the forms in general, about the business, feel free to reach out to the legal hotline Mondays, Wednesdays, Fridays, 10 to noon and 2 to 4. The phone number is 443-716-3502. Or I always say this, if you are the kind of person who wakes up at 2 o'clock in the morning on a Saturday and has some burning question, you can call James at, no, I'm just kidding. No, you cannot. If you wake up at 2 o'clock on a Saturday, you may go online and you can submit your question electronically. It'll be assigned to one of the attorneys on a Monday morning, and we'll respond within 48 hours.
Yeah, please visit mdrealtor.org. If you go to the legal tab at the top of the page, you'll then see a link to our legal hotline page. It explains all of the different parameters that you should be aware of in terms of asking legal hotline questions, but also gives you a link to the place where you can submit written questions. And we just ask that you give us a couple of business days to respond to your written questions. And if you're going to submit a question in writing, give us a chance to respond in writing before you give us a call, and vice versa. We always appreciate that as well. But again, thank you so much for your time. We appreciate it and hope that you enjoyed this webinar.
Thank you.